But that you were the conduct of not more speaking further enough that we're not going to go down Ohio statute, but pictures might show infants, so we're not going to go through all the possible scenarios. And I would just look at the case. As large as give the facts, and then story. They say that's really just lay it out there. It's based on other cases and so forth. But trying to rational reasonable arguments to support a higher age. The same argument. Then it goes through all the reasons why it's rational for making an age of a child or a minor higher than including teenagers are aware of the possible consequences of sexual conduct in classes on what the game is talking about. Dangerous appearance and photographs, memorialized, give that picture or video, it's there forever. They're for years, years, once someone's on the internet, it's out there. What happened in my mom? That 17-year-old girl, and he took his roommate. We said, this was never meant to be distributed. We made a great point. We said, there's no guarantee. Private photographic images laws are being included for a variety of reasons. Once private material is made public by accident, after the accident. So at the age of the definition of a child and sexual orientation
That was a lot.
All right. Oh, come to order. You may be seated.
All right, I hope everyone had a good lunch and we're ready to resume the proceedings in the Texas State Court versus heard arguments from the defendant regarding their motion 16. I've heard a response from news outlets that are represented, and then I believe the state had remarks they wanted to make, and then I'll hear again from Mr. Phillips.
Thank you, Your Honor. To begin with, Judge, as a state, we really don't have too much of a dog in the fight. I think what we prepared to do is to make sure our understanding of the proper standards and things were addressed, and I believe by both sides those have been addressed. One thing we did want to, I know as a state, just related, Your Honor, as far as some recent case law and things of that nature, is the concern appellate courts have had with closing the courtroom. As recently as Freeman versus the state, which was 328 Georgia Appeals 756. That was a 2014 case. That was a case where the conviction was upheld and there was a closed courtroom based upon an agreement by both the state and the defense. Yet even in that case there was a dissent, even by agreement of parties, where one of the appellate judges said that they would have reversed because of the I guess strict scrutiny that the courts have against closing a courtroom. So that kind of informed our skepticism to a point as far as closing a courtroom. I would address specifically, now that we've received this suggested order by the defense, heard their arguments and evidence, and the argument by the media, having looked at the order, we do disagree specifically with that order and how it's worded, and specifically what they are asking to do specifically in this case. I would just first off point out, if you look at the order, it states that they are seeking to have the defense attorney as the filter, or the defense as the filter, to notify the court when prosecution evidence is coming forward or is going to be produced in a hearing. Judge, there's nothing in that order whatsoever to stop defense evidence in this case. I think additionally, when you're looking at evidence in the case, that is something that can be tested via cross-examination and things of that nature. What could be even more wholly prejudicial would be argument. We've already had argument in this courtroom here today, which is not necessarily tested by cross-examination, by evidence, and by the rules of evidence and things of that nature. As we've seen Facebook posts here on the screen today, only parts of which were shown, Your Honor. We have had argument before this court that we've not had evidence to support. We've had argument that was actually taken up before this, talking about the return of items from the defendant's cubicle that his son has made for him. Return of a laptop. Things that, if we're really worried about that, we could have taken up afterward, or the defense could have taken up afterward, but that is something that now has been put out before this court and before the public as well, these requests. So, Judge, initially I would just say that this order is improper in that it's only addressing prosecution evidence and is filtered through the defense. I do think, having listened to the defense's presentation and the arguments of the media, I would have to agree that I don't think the defense has met this high burden of showing enough to close the courtroom and not addressing the other alternatives. Just a couple of things to perfect the record and some things to point out that the state has noticed through the argument. First of all, in talking about whether it's been proven that jurors have been so prejudiced, or there's proof that jurors could be so prejudiced there cannot be a fair trial in the case, looking at some of the proffers here. Starting off with the defense, they talked about a newspaper article in the Marietta Daily Journal on the 19th of June 2014. They pointed out one quote from an eyewitness on the scene. What the defense failed to talk about and address, which is in those articles, are the favorable coverage that may be unfair to the state or unfair to the truth, but favorable coverage in this case. Also, another thing that wasn't discussed was this whole, I guess, the attention started because of the negative publicity about what the police or the prosecutor was doing and the, I guess, saturation of positive reinforcement for the defendant and by his supporters. You'll see in the articles you have there were online petitions, there were web videos created attacking the DA in this case. All of the media attention to begin, when this case started, was all positive. But again, as I think Mr. Clyde talked about, these things are already out in the media and they're there. Also, the June 24th article, there were positive influences. June 27th article talking about the autopsy report and the explanation in the paper about the fact that it was because the cause of death and manner of death, and they said that the investigation was leaning toward it being homicide. Here today they introduced the cover page of an autopsy report, the defense does. We don't have the full autopsy report or anything like that. Again, every stage, not just the evidence, but every stage of arguing any motions in this case has the possibility of shaping public opinion one way or another. There was talk about talking heads, local attorneys speaking in favor of District Attorney Reynolds and his opinions of the case in that regard. You will also notice in another article there was mention by other talking head attorneys stating that, I believe it was, to summarize, the state doesn't care about fair, they just want convictions. So again, this isn't something that is showing this huge prejudice against the defendant. This is something that's out there. We're going to have talking heads on almost every case in America now taking one position or the other. So it isn't fair to say they're all supporting the state or the defense in this case. There was talk of a picture of the defendant that was unflattering and how that could negatively affect the jury pool. Looking at another high-profile case that happened just years back in Georgia, the Brian Nichols case, the media was flooded and the nation was flooded with photographs and video of the defendant being led out of the apartment in handcuffs by a number of police officers. That case, they found a jury and picked a jury in Fulton County. In that case, actually, there was a confession that the defendant made that was played over and over again or recited, talked about over and over again in the media. Yet, they still were able to get a jury. There was mention of bad character and people talking about the bad character of the defendant in some of these articles. They're also talking in these articles and some that aren't provided about the defendant's good character by his family members and friends and things of that nature. One other post that I think was cited or tendered to Your Honor was an examiner.com website. I don't even know what that is. The defense made a statement, though, that they had mischaracterized what the evidence was and that it doesn't matter where it comes from. It does, because this examiner.com, I would submit, is not a national media website. It could not affect a great amount of the population. The defense, I guess, theorized that anybody could pull it up, but there's no proof that A, anybody has, or B, anybody will. Although they may now that they put it out there, there's no proof that it has affected the jury pool whatsoever. I don't think you can stop fringe bloggers on any topic this day. They're going to be out there no matter what we do in almost any case. So, Your Honor, looking at those, the other possible avenues and alternatives to closing the courtroom, I think we talked about a few of those both parties had. As far as changing venue in this case, one thing that had been discussed was if you can't move it anywhere if it can't be in Cobb. Basically, everybody's going to know about it. However, if you look at the number of articles and how they diminish as you get further away from Marietta, almost that whole first stack are Marietta Daily Journal articles because it's in this community. As you go further away, who knows? There aren't any articles cited from the Augusta Chronicle and how they've covered it, Savannah, any of these other areas. So I don't believe they have met their burden of showing that a change of venue would not work in this case. Also, regarding searching voir dire, I believe that the media talked about it as far in depth as you can. There have been a number of other much more high-profile cases that have been handled in recent times in the current media age where, in spite of this coverage, courts have been able to get fair and impartial jurors to hear the case. So, Judge, at this point, having looked at that order and the way the defense has presented it and having heard argument, the state would ask you not to sign that order requested by the defense, as I believe, A, I don't believe you want to sign on to some of the opinions that are given in the order as findings of the court, but B, I don't believe the requests are appropriate as far as how they limit it only for certain things and not others. And if you really want to stop any coverage by the media whatsoever of this going forward. What they've asked for will not work.
Just a few follow-up points, Judge. Mr. Clyde pointed out a couple of decisions. If I heard him correctly, it was the Rockdale Citizen cases in 95 and 96 to suggest that somehow that made the Southeastern case not good law or diminished it somehow. Well, that's just not the case. I've submitted that case to you and given you a copy of it because it is good law. And the reason why it was upheld was because the trial judge did exactly what we're doing in this case. I've submitted an order to the court that is very specific and narrowly drawn and covers all of the basis in the Lumpkin case. That did not happen in the Rockdale Citizen cases. In fact, the first time that case was decided, it just point blank, the court did not address the other possible measures. And the court found that it simply did not carry its burden under Lumpkin, didn't meet the requirements, procedural requirements, and lay out that which was required under Lumpkin. The case then got sent back to the trial court, and in the meantime, venue had been changed. So they had this huge change that occurred, and apparently without any additional information or evidence, the trial court turned around and still closed the courtroom, even though venue had changed. And in the second Rockdale case, which was 266 Georgia 579, and that was a 1996 decision, that's what the court said. Given the change of venue in this case, there exists no evidence to support closure of all pretrial evidentiary hearings. So I thought it important that you understand exactly what those cases say, and they certainly don't indicate that Southeastern is not good law. And I submit to the court the order that we've submitted makes detailed and specific findings supported by the record and meets all the procedural requirements under the Lumpkin case. That is, that the order is narrowly tailored for closure only for motions where prosecution evidence is disclosed and discussed. I understand counsel's argument that, well, what about defense evidence? Well, what about defense evidence? None of these cases address anything like that. That's not a, I suppose if the state wants to file a motion challenging some evidence that they expect us to put in, well, I guess they could file a closure motion as well, and we would hear it. But that's not an issue before the court. So I think, at best, that's a specious argument. Mr. Clyde commented upon the order in that, well, clearly we've not met our burden because we're suggesting some procedure that's not appropriate. Let's just have an order closing everything, just grand order closing everything, and then, well, we'll have in-camera hearings and determine which ones we really want to close. Well, that's not at all what the order says. That's not at all what I suggested to the court. In fact, the order is very, very narrowly drawn. Specifically, closure for pretrial motions where there's an expectation that prosecution evidence is going to be disclosed and discussed. And this is the same kind of closure that's talked about in these cases. Here, the motions which we submit would require disclosure of prosecution evidence at this juncture, before we've obviously filed the motions in limine, any as-applied constitutional challenges. Well, Mr. Clyde suggests that, well, you know, if you're just challenging a constitutionality of a statute, that's just a legal argument. Well, that's not accurate. An as-applied constitutional challenge is just that, the statute as applied to the facts of this case. So the evidence has to be discussed to some extent in any as-applied constitutional challenge. We filed several of them in this case, and we expect evidence is going to have to be discussed and disclosed. Second is severance motion. That's the most problematic, because in the severance motion, Judge, essentially we're going to have to lay bare the evidence which we think is going to come before the court in all of the counts. Everything. Otherwise, how can the court possibly make a determination whether or not joinder is improper, whether or not severance is in fact required? And of course, motion to suppress, that's obvious. That's going to be a substantial discussion of expected trial evidence. I want to touch briefly on Mr. Boring did mention the Freeman case. I was going to bring that up, but I've got a little bit different take on that. It appears to me that in the Freeman case, and this was just last year, closure of the courtroom was upheld. Now, it was for a very limited purpose. It was for a sentencing hearing for a particular witness, but it was nonetheless upheld. And I suggest to the court, and there was no constitutional right that served as the basis for the closure. In that case, the court upheld the closure, finding essentially that the state's right to protect an ongoing criminal investigation in an unrelated case was sufficient for a limited closure of the courtroom. And I submit to the court the reason why that case was affirmed is because they did exactly what we're doing here. They're following specifically the procedural requirements in Lumpkin and making the findings that are required in Lumpkin. And finally, Judge, obviously, I'm not suggesting that it is an unfair argument to call attention to other cases of notoriety. I think that's probably a fair argument. Certainly, in the state of Georgia, we've seen from time to time bigger cases. The crematory case, Brian Nichols case, Lynn Turner, Snyderman case. I understand that. I don't think it's unfair to make some analogy, but I really don't care about those cases. I don't represent those people. I represent Ross Harris. And I don't know what motions they filed. I don't know that closure was argued. I don't know that it was sought in any way, shape, or form. Don't know. Wasn't involved in those cases and don't care. But in this case, I think you've got a template of exactly the clear and present danger we've discussed, and that is what happened via the preliminary hearing. We have a preliminary hearing wherein prosecution evidence is disclosed and discussed. You pick up any paper, you turn into any telecast in the weeks thereafter, and it's very clear it had a substantial negative effect on public opinion. That is the template for exactly what is going to happen if we continue allowing any and all disclosure of prosecution evidence and then just really hope for the best. If it's excluded, well, we'll deal with it. If it's limited, we'll deal with it. If it's, we'll deal with it. So I submit that the order, Judge, will withstand scrutiny. I would ask you to please look at the video links that we've submitted. Take a look at these take a look at these, the evidence that we've submitted in these cases. The safest thing for this court to do is to grant our motion. And the reason why is because by granting our motion, you're doing two things. You're absolutely guaranteeing a fair trial for Mr. Harris from this unfair pretrial publicity. You're guaranteeing that. But secondly, you're guaranteeing that it is going to be reviewed. It is a no-lose for the court, because the lawyers for the media have got the right to take it up to the Supreme Court on an expedited basis. Let them take a look at it. If we're wrong, so be it. They'll send it back down and say we're wrong. I don't think that's what they're going to say, but I believe that would be the safest and the most appropriate way for the court to handle this motion. We would ask that you grant it. Thank you.
Well, the court has reviewed, and did so over the weekend, in fact, the motions that have been filed. Reviewed the proffers that have been made. Reviewed the opposition response briefs from the media outlets. Listened carefully to argument, and I make the following decision and ruling. And the ruling I make is as follows. Defendant Justin Ross Harris's motion for limited closure of courtroom for certain pretrial motions is hereby denied, and for the following reasons. Closed proceedings must be rare and only for cost shown that outweighs the value of openness. If the interest asserted by the defendant is the right of the accused to a fair trial, and that is the assertion that's been made today, the motion hearings shall be closed only if specific findings are made demonstrating that, first, there is a substantial probability that the defendant's right to a fair trial will be prejudiced by publicity that closure would prevent. And I don't find that to be the case. Much of what is complained of here is information that is already in the public purview. It's already been disseminated from coverage at the beginning of the events leading to the vote of indictment, coverage of the preliminary hearing, and conversations within the public through social media and through media outlets. And secondly, about reasonable alternatives. They don't need to be addressed because of my prior ruling, but I find that alternatives for dire, thorough and sifting, specific and direct instructions from the court would in all likelihood be adequate to deal with pretrial publicity. It has been in the past in other cases and would likely be in this case. Although until you got into jury selection, you'd have no definitive way of knowing. And then that leaves as last result a change of venue. It's important to note that Georgia is more protected than federal law of open courtrooms. And the fact of the matter is that we are dealing with an electronic age of media, of 24/7 news coverage cycles, that this is the new norm and will apply to all cases now and in the future that attract public attention. If closing courtrooms is the answer to that, then vacates the First Amendment, and we're not here to do that. So for those reasons and others expressed in specifically the news media's opposition, their briefs, based on case law and based on the evidence before this court, I deny the motion.
Judge, will you be issuing a written order on that now,
Well, I think I probably need to,
please?
of course. Who wants to submit a proposed order as they anxiously want to raise their hand?
I'm sure we'd be happy to submit a
I think it would be very nice if you would work with the state's attorneys,
Sure, we'd be
getting
happy.
something that's appropriate and consistent with the rulings I've made from the bench.
We'd be happy to do that, Your Honor.
Thank you. All right, let's.
May we be excused?
Please. You don't want to stay?
We have representatives.
All right, we have much more work to be done. Mr. Coble, when you're ready to go forward, I know you need to make some notes.
Okay.
It's going to be strong.
To please the court, I'll go.
Butler, what motion are you addressing?
I believe it's motion number 7, Your Honor, starting the motion to quash due to the cruel and unusual punishment of the provision in count 3.
I have it in front of me.
Thank you, Your Honor, for giving me a moment to get set up here. I truly anticipate and hope that this will control my timing in presenting our motion. So, it's time well
That's a
spent.
novel and interesting thought.
We're going to see how it works, Judge. You may be setting precedent here today. With regards to Vince's motion, number 7, we have filed a motion seeking to quash this indictment because count 3, as it is alleged by the state, alleges that Mr. Harris is subject to the offense of felony murder based upon cruelty to children in the 2nd degree. Now, that's a unique charge separate from all the other charges in the indictment. That's important to note. He's charged with count 1 and count 2, which are 2 alternative theories of murder. And then count 3 alleges this very, very specific type of murder. Our position, Your Honor, is regarding this count that the sentencing provision, which would be a mandatory life sentencing provision, is cruel and unusual punishment because of what the state itself has told us, what the Supreme Court has told us, what our governor has told us, and what our common decency in society mores tell us. And so that's what we want to address in our motion today.
Judge, if I may, I don't know if I should object or maybe interject. I think we have an issue of rightness about whether we should even hear this right now. I don't know if the defense has an argument on that. If so, that may need to be heard first because the state contends this is not even right for argument right now.
Why is it not right? Because we're not, we haven't seen what the jury may or may not do in the count.
That's absolutely correct, Judge. Under Supreme Court precedent in Brinkley, Jones, and Woods, courts have held that the proper time to bring a constitutional attack in this regard is after a verdict and only after a verdict. And so I have the cases to provide and cite further, but I don't know if the defense already wants to make their argument regarding that, but I think that needs to be handled first.
What do you say about handling the sequence?
I don't believe it needs to be handled first. I certainly will address it. They provided me with a brief this morning, which raises that for the first time. I've had a limited time this morning to look into that, and I think our Recent case law tells us quite the opposite of their position, and I think there's a very specific reason why they're looking at the Brinkley case and taking it out of context, and so I'll address that in the midst of my argument, Your Honor.
I don't have a problem with that. Make it a component of the argument, and then you can respond and develop it a bit more, because you didn't have last say anyway.
Thank you, Your Honor.
Thank you, Your Honor.
The issue on this motion, Your Honor, is a mandatory life sentence for murder based upon cruelty to children in the second degree is unconstitutional. That's the defense position. And looking at that, here's what we're going to be outlining to the court today. There are some constitutional protections, both federal and state, that come into play, obviously. There's a statutory punishment, which is a mandatory life sentence for this very specific type of crime that we're dealing with. We also have Supreme Court rules that are very, very important, and this is what we'll, I know the gist of our argument will focus on this. Supreme Court tells us that cruel and unusual punishment is not a static concept. There is an evolving standard of decency that the court has to look at each time that a case comes before the court to look at the specific offense, the specific punishment, to determine what, in fact, is considered cruel and unusual. And very importantly, the court has told us multiple times, the legislative action, which we have in this case, is the most objective and the clearest and best evidence we have regarding society's evolving standards. What we're going to see in this case is a very unique situation legislatively that goes with this very unique case that we're dealing with. The legislative changes, let's talk a little bit about that. Prior to 2014, felony murder law punished the causing of death while in the commission of a felony, as the court is well aware. That punishment changed in 2014 when our General Assembly created a very specific crime with a very specific penalty, different from every other murder case, every other murder charge in the state of Georgia. That offense is murder in the second degree, which is based solely upon second degree child cruelty. So not only do we have new legislation, we've got a new legislation that deals with a very specific offense, which deals with a very specific predicate offense that can be used to base it upon. Prior to 2014, the felony murder law required the court to impose a mandatory life sentence if one was found guilty of that offense. No discretion whatsoever. In 2014, all of a sudden now this court has given some discretion and a range of punishment from 10 to 30 years for this very specific type of offense, very specific type of crime. We're also going to look at applying these constitutional rules to our specific case. In doing so, we were going to point the court to this legislative change being the objectively and clearly proving this evolving standard of acceptable punishment, which the Supreme Court has told us is the most objective and clear evidence that we have. Because of that, the mandatory life sentence is now to be considered cruel and unusual punishment for this particular alleged offense in count 3. Let's start with the basics. Our constitutional protections. We're always mindful that our constitutional rights are what are at issue. They're the most basic rights that we have. And if we start anywhere from other than that, then we lose sight of the importance of what we're dealing with here. I think the state's position regarding whether this is ripe or not does exactly that. It fails to note the constitutional protection that has to be in place for every citizen and certainly is in place for Mr. Harris. There's also a Georgia state constitutional provision that we'll look at as well. The 8th Amendment to the United States Constitution, as we'll all remember, says that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. There's our basic right. Georgia Constitution, Article 1, Section 1, Paragraph 17 says excessive bail should not be required, nor excessive fines be imposed, nor cruel and unusual punishments inflicted. And there's some additional rights there in the Georgia State Constitution. So we want to be very clear. We're going upon both the Georgia Constitution as well as the federal United States Constitution. Here's the statutory punishment that we're talking about. Felony murder predicated upon cruelty to children in the second degree, mandatory life sentence. And the fact that that's mandatory is especially important in this analysis as well. Because if there were some discretion, if there were a range of years to look at, then the state's position regarding whether this is ripe or not may be a valid point. But because there's only one option the court would have if a jury returned a verdict as to this specific count, it takes us out of the realm of where the state is trying to procedurally bar us from addressing the constitutional rights of Mr. Harris. Supreme Court rules. Fleming v. Zant, 259 Georgia, 687, 1989. Tells us, or it was dealing with a cruel and unusual punishment challenge to the death sentence based upon some legislation that occurred after the trial, and it prohibited the execution of the mentally retarded, and that's the language that they use in that opinion, so that's why I'm using it, Your Honor. In looking at that case, this court told us whether a particular punishment is cruel and unusual is not a static concept, but instead it changes in recognition of the evolving standards of decency that mark the progress of a maturing society. The defense is asking that this court impose the evolving standard of decency that marks our maturing society. The same standard that our state legislature, our very own governor, has determined to be the proper mark. In Fleming v. Zant, they held that the legislative enactment reflects a decision by the people of Georgia that the execution of mentally retarded offenders makes no measurable contribution to acceptable goals of punishment. Even though that was the punishment that was in place at the trial occurred, even though that was an acceptable punishment at one point in time, the court recognized the evolving standard of decency. The court must impose that in its cruel and unusual analysis. That post-trial legislation prohibiting the execution of mentally retarded held to be evidence of a new standard of an acceptable punishment. Secondarily, we have Humphrey v. Wilson, 282 Georgia, 520, 2007 Georgia Supreme Court case. Probably very familiar to most of us in this courtroom as it dealt with our neighboring county in Douglasville regarding the Gennaro Wilson case, as it's often referred to as. In Humphrey v. Wilson, there was a cruel and unusual challenge to the statutory punishment for consensual sexual activity between a 17 and a 15-year-old. As the court will recall in that case, there's a minimum mandatory sentence of 10 years in prison that in fact was imposed upon Mr. Wilson because that was the only punishment that was allowed at that point in time that he was committing the alleged offense, went to trial, was found guilty, and was sentenced. The court had no discretion to go outside or at least below the minimum mandatory. In that case, we saw again post-trial legislation reducing a sentence to a misdemeanor. As the court will recall, our legislature came about and decided that this sort of activity that was at issue in Wilson, if within a very specific range of age, if a consensual activity would no longer be a felony offense, not only would it not be a minimum mandatory of 10 years, but it would no longer be a felony offense, but would be a misdemeanor offense. And they held that that was in fact this new standard of acceptable punishment. Now here's what's interesting. In looking at the Wilson case, helping us to understand why our case is so much more rare even than the Wilson case. The incident occurred December 31st, 2003, that Mr. Wilson was charged with. He went to trial in February of 2005. In April of 2006, over a year after his trial and sentencing, April 26, 2006, the legislature amended this law, and it was signed by the governor, changing the offense from a minimum mandatory felony, 10 years to serve, to a misdemeanor offense. Ironically, 2 days later, the Court of Appeals heard that case, actually issued its opinion in the appeal and affirmed the decision on appeal. The defense then filed a motion for reconsideration based on the new law, and that was denied. That law in the Wilson case did not go into effect until July 1st of 2006. A habeas petition was filed in 2007, and habeas was granted in June of 2007. The offense was in December of 2003. The granting of habeas based on this exact same question was granted in 2007, some 3+ years later, after the fact. And then ultimately the Supreme Court issued its decision on October 26 of 2007 affirming the habeas court. Now that timing is very, very, very key. It goes to the importance of looking at this case as a very unique case. It goes to the timing issue the state's now raising. It goes to show how important this constitutional protection is. Even though we're looking at years after the fact, a change in the law at the point in time that we're imposing that sentence upon someone, our Supreme Court determined that that was sufficient to show a cruel and unusual punishment, a change in our decency standards that had to be affirmed. Now, in Humphrey v. Wilson, here's what the court told us. Legislative enactments are the clearest and best evidence of a society's evolving standard of decency and of how contemporary society views a particular punishment. I know we've heard that before, but I want it to be very clear. These are not concepts that we're coming up with off the top of our head. This is what our Supreme Court has told us is the law of the state of Georgia. Clearest and best evidence, the evolving standard of decency. Prior to 2014, a mandatory punishment for this offense, for the felony murder offense, for which Mr. Harris is now charged, is life, life without parole, or death. 2014, with the legislative change, we lowered that penalty outside of those harshest of sentences. Not even an option in those cases. It is now a felony murder based upon secondary child cruelty carries a 10 to 30 year sentence. So completely obliterating all these sentencing options that were in place prior to 2014. I put off to the court, I think I had it put there to be marked. Is that defense exhibit number?
It's not
Whenever you have it
from the
marked.
Secretary of State.
It is a certified copy of the Secretary of State's, from the Secretary of State's office of this, the passage of this law. I'll provide a copy to the states. Copy I provide to the state simply has the certification, the dates page, and the first page. There are several other pages regarding other parts of the law that are not relevant for this discussion. We would tender that as defense exhibit number. I don't know if you want us to start over for this hearing or keep it going from the last number. Does the court have a preference?
Well, that's a good question. Brian, what's going to be easiest for you? Keep it now.
Thank you very much. What number will that mean, Brian? Number 14. Thank you very much. What defense exhibit number 14 shows us is that the state of Georgia, through its elected representatives, established for us what the standard of decency was for this particular crime. What you'll see when you look on the second page of that document is that this item was voted upon by the House and by the Senate, passed by both bodies with 3 nay votes to 217 yay votes. So to anyone's question as to whether or not this is telling us exactly what is the decency normal for society in the state of Georgia, there should be no question. That was done on March 27th, 2014. Our very own governor, Nathan Deal, approved of this as well. He specifically signed this bill on April 22nd, 2014. On April 22nd, 2014, Cooper Harris was still alive. And it wasn't until June, some nearly 2 months later, before this incident even occurs. And that's very, very important because when we see the Wilson case and how that shows us the timing of what's important regarding the timing, here we have the amended law actually signed by the governor before this incident ever occurred. Unfortunately, on June 18, 2014, we have Cooper's death. Less than 2 weeks later, that law, which had already been voted upon, agreed upon, signed upon, became legally effective July 1st, 2014. When we compare that to the Wilson case, we see in the Wilson case it was still considered cruel and unusual punishment, even though that law didn't even exist at the time the incident occurred. Even though the law didn't even exist at the time he went to trial and was sentenced. The law didn't even exist for a whole other year. And the court still saw very clearly that it was cruel and unusual punishment to continue to punish Mr. Wilson under the law as it existed at the time of the offense. Here we are in September 2015 with motions over a year later after we've been told very clearly and directed as to what our evolving standard of decency is. This trial will occur in 2016. We're going to be now nearly 2 years from that time frame. Let's look at the Supreme Court rules regarding motion to quash. Our United States Supreme Court has given us a way to analyze these issues. Harmelin versus Michigan, which is 501 U.S. 957, 1991 case, and Ewing versus California, 538 U.S. 11, 2003. And Your Honor, I'm certainly glad to provide an electronic copy of these cases to the court at a later time if that'd be helpful. Didn't want to provide all that documentation to the court at this point, but we'll certainly follow up with that if that's agreeable. In these cases, we got an analysis. How do we determine if punishment is in fact cruel and unusual? There's a two-step process. First of all, we examine the gravity of the offense compared to the harshness of the penalty. When we do that, we may come up with a threshold inference of gross disproportionality. Fancy language which basically says, if we look and see what the crime is and we see what the punishment is, if there's something that tells us, wow, that punishment is too harsh, then it's cruel and unusual punishment. That's simply stated what we're talking about here. The second step is if we get that threshold met, is the judgment of disproportionality confirmed by comparing this type of sentence to sentences for other crimes within the state of Georgia or within the jurisdiction as the Supreme Court was talking about it, and then also comparing it for the same crime in other jurisdictions and what their punishment is. Let's look at that analysis. First of all, the threshold inference. What Ewing versus California tells us is whether the sentence furthers a legitimate penological goal. In other words, is there a true punishment goal that we believe is proper to be imposed for this particular sentence? In doing that and looking at that, here's what our Georgia courts have told us. Bradshaw v. State, 284 Georgia, 675, 2008. Let's look at the severity of the punishment. What is the severity of the punishment as it was pre-2014? Death, life without parole, or life. Mandatory. No discretion. So, is this a severe punishment we're talking about? Absolutely. Absolutely. Now, this is not a death penalty case, I recognize that. But Mr. Harris stands here today facing the potential for this particular offense, as well as others, life without parole and a life sentence. When we see those options, what the courts have told us, what the Wilson court told us, what the Bradshaw court told us, was absolutely, absolutely. If that's the harshest of offenses, I mean, that's the harshest of sentences, how could it be considered anything but harsh? Now, is it cruel and unusual? We have to take it a step further. Then we look at how is the legislature speaking to us about that punishment? Because here's what the courts tell us, and I believe Your Honor will agree with this. The courts are simply in place to judicially administer the laws as our elected legislature has put them together. Some folks have another idea, well, maybe the court should just kind of make up the laws as it goes along. I don't think this court believes that. I believe this court understands and appreciates that when the legislature speaks on behalf of elected officials speak on behalf of its constituency, that is the first point, and maybe even the last point that we look at, unless and until a constitutional provision comes into play. And then Your Honor has to take that next step and act in a certain way to make sure that Mr. Harris, the state, the defense, whoever's at issue, their constitutional rights are protected. What does the recent legislative enactment tell us? Well, it tells us that this specific crime, not a whole litany of others, but this specific, there's something unusual about this specific crime, that we're going to lower that sentence level. No longer is a life sentence proper. No longer is the potential of a death sentence proper. No longer is life without parole should even be considered. For this specific offense, it should be lowered to 10 to 30 years. in trying to understand where the legislature was going with that, we can't delve into that necessarily. Some might argue, well, maybe it's because we just wanted to make sure that these sort of offenses were being prosecuted. Well, if that's the case, then that means Mr. Harris was even in a better position, because the thought was that this wasn't even a prosecutable offense until this new law came about. But what we're stuck with is what the law tells us of where it was. Felony murder was in the commission of any felony that death was caused, then it's a mandatory sentence. But our legislature told us no longer was that proper. Dawson v. State, a case dealing with another mandatory sentence, talks about the idea of a passive felony. This was the life sentence that used to be in place for failure to register as a sex offender. And it questions, well, should this sort of crime be punished more harsh than much more violent crimes, much more intentional crimes, much more severe crimes, where people are actually going out and doing intentionally harsh things to people, such as aggravated assault, pulling a gun on someone, shooting them, shooting at them, carried a maximum of 20 years, still does. But in Dawson, looking at the failure to register, carried a life sentence. Look at vehicular homicide, a non-malice offense. Taking the life of someone after you intentionally get behind the wheel in a state in which you're unable to safely drive. That's worth 15 years. Now, no one at all is going to argue in any way that it's anything but tragic and horrible what happened to Cooper Harris on this day. But there was no intentional action as relates to this particular count. Even the state apparently agrees, because they saw an indictment for it, that this is a count based upon criminal negligence and failure to act, and omission. Was this a passive felony? Absolutely. Should the failure to remember your child, as horrible as the result was, should that be treated the same as someone who commits a home invasion at gunpoint, wearing masks, coming into someone's house and holding them at gunpoint? Burglary carries 20 years. Aggravated assault, 20 years. In this case, they're seeking a life sentence for an omission as to this particular count. We're only punishing criminal negligence, and only is a relative term, obviously. It's a very unique indictment that we're dealing with here. We have the state, which on one hand is indicting intentional, malicious acts of murder, as well as an intentional, malicious act of felony murder based upon first-degree child cruelty. But it's not enough. They then want to come up with count 3 and charge second-degree child cruelty, which is a negligence level of offense. When we look at this threshold question, what we see is in the state of Georgia, we have the highest available sentence with some recent pre-offense legislation that changed that to say that was no longer valid. And we're dealing with a non-malicious, non-forcible felony by the state's own indictment. There's no questioning of that. What's our conclusion then? There's been a threshold inference of gross disproportionality made in this case. Wilson tells us that, and many of the cases that deal with this issue tell us, it's a rare case that you're even going to get to this point or satisfy this threshold. Well, if it's not been clear from what we've seen already today, what the court knows about this case, what we see in this particular count of the indictment, this is a rare case. The rarest of cases. And this is the rarest of legislation that has come about to speak, to tell the state who's taken an oath to follow the law of the state of Georgia and told them we no longer see a life sentence, if we ever did, as an appropriate remedy or punishment for this specific offense. So when we meet the threshold level, we go to question, step number 2 of our analysis. Can that disproportionality be confirmed? Even if we think, yeah, it just seems like it's going unusual, let's look and see more in depth how it looks to other statutes. How do we do that again? Are other Georgia crimes more violent nature punished more highly? Absolutely. That's what we were just talking about. We don't have time to go through the litany of offenses within the state of Georgia, but we've talked about them already. Aggravated assault, child molestation, burglary, just to name a few, all of which have a lesser punishment than this failure to act negligent offense. So, to that question, are we punishing this more highly than more violent crimes? Absolutely. I understand the end result is harsh. No one's questioning that. But what we seek to do when we punish and we set out sentences and offenses and punishment levels is how do we deal with the person who made a decision to commit this crime? How do we deal with that? And when looking at that, when we are dealt with this specific type of charge, a negligence action, we see it being punished more highly than much more intentional, much more violent crimes. Number two, we also want to look at other states. Do they punish this similar offense in a similar fashion? And here's what's interesting when you look around the country. 50 states, all of which have their own legislatures, their own ideas, trying to determine what is their evolving standard of decency for their particular people. In my review of those 50 states, only two, as of 2014 at least, still had a life sentence for a felony murder level offense. What we see, in contrast to what we have in Georgia, is criminally negligent homicide statutes are coming about. They range everywhere from misdemeanor level punishment, some up to 10, 20 years. One state even goes as high as 40 years. But none of which have indicated that our standard of decency is still punishing this offense as a life sentence. There are several states, 8 of which, that have very specific laws regarding the death of a child due to criminal negligence. And looking at those, we also see a wide range of punishment. We have 2 notably, interestingly at least to the defense. The state of Oregon has a very specific offense dealing with leaving a child in a place that would endanger their health. It's punished as a Class A misdemeanor. There is a criminal negligence homicide statute that is a Class B felony. I'm not a specialist in Oregon's law, so I can't tell you if they have the rule of lenity or not and how that would affect it. But interestingly, the most specific offense to this particular allegation here, considered a misdemeanor. Secondarily, the state of Kentucky has a manslaughter in the second degree, a Class C felony, which involves leaving a child in a vehicle. I think what we're seeing, Judge, is states around our country are seeing this type of tragic event and trying to figure out how do we deal with it. Some of which don't even have, many of which don't even have criminally negligent homicide statutes at all. Some will only go as far as a reckless mens rea. We obviously have a premeditation, intentional mens rea, a knowing, maybe even a intentionally committing of a felony with certain specific offenses that are included in that. And then some that have a reckless. And a few that have added a criminally negligent. And that number is 23 states now have a specific criminally negligent statute. We're not bound by exactly what all those states do, but what the courts have told us is it's helpful to this court and its analysis to say, well, let's see, can we confirm what we see happening in the state of Georgia, meeting our threshold of being disproportionate? Are we seeing the same thing happening around the country? Because if we see that, then that gives us a little more comfort that in fact we can truly see that the standard of decency has evolved. We have matured as a society, and we've decided that a life sentence is no longer appropriate for this alleged offense. When we look at that second step, we see higher punishment for less violent offense here in Georgia. We see a higher sentence than we have in Georgia in 48 other states. It's overwhelming. What's our conclusion? We can confirm that there's a disproportionality in this particular sentencing level that the state has brought forward against Mr. Harris. Looking at the state's brief regarding the timing of this motion. They indicate, and they cited to Brinkley versus the state, 291 Georgia 195, 2012 opinion. I got a chance to look at it briefly this morning as Mr. Kilgore was presenting his case. That case isn't dealing with this type of offense at all. In fact, the cruel and unusual punishment argument in that case isn't even made against a criminal statute. It's against a sentencing statute. The state mentions that in page 2 of its brief and indicates that the first opportunity a defendant has to bring a constitutional attack against a sentencing statute, as opposed to other types of statutes, may come only after the guilty verdict is returned and the sentencing issue becomes ripe. Now, when I read that this morning, I thought, that's an interesting issue. And it seems to have a ring of comfort to us. Well, how do I know if it's cruel and unusual punishment until after I've actually seen what the punishment is? Well, in this case, we don't have any question about what it would be because it's mandatory. It's a mandatory life sentence. But in this case, we're dealing with the constitutionality of a specific statute, not of a sentencing statute, not 1710.6.1, which I believe was involved in the Brinkley case. But I'm not smart enough to figure that out on my own, frankly. I wanted to see where was Brinkley cited, see what the court's told us since then. Well, here's what the court's told us. In March of this year, in Jones v. State, I have the docket number Supreme Court 14A 1702. The court says the appellant did not raise this in the Jones case, again, a cruel and unusual punishment claim. The appellant did not raise this constitutional claim at or before his sentencing or in his motion for new trial. Well, that tells me the court recognizes that absolutely you don't have to wait till sentencing to raise cruel and unusual punishment, a constitutional protection. I don't have to wait and see if you're going to violate my constitutional rights. When I see a potential issue there, I can raise it, and that's before sentencing. And also, Pierce, which is 322 Georgia Appeal 145, 2013 case, it says, a constitutional attack on a state statute must be made at the first opportunity, and it is too late to raise such question after a guilty verdict has been returned by the fact finder. Well, if it's too late to do it after the guilty verdict, well, sentencing doesn't happen until after that. So to the state's position that this is not right, it has to wait until sentencing is done, the court is telling us, no, that's not the case. When we're looking at a very specific sentencing statute question, which they were in Brinkley, that's a different issue. Because I'm not challenging what I'm being charged with. I'm challenging what the legislature said what the ultimate punishment would be. In this case, it is the statute itself that charges this offense that sets out the sentencing structure. And to suggest we can't and shouldn't bring forth a constitutional challenge at this point in time, frankly, in light of the procedural bars that the state usually wants to put up in front of seeking remedy for a constitutional violation, just simply doesn't match up, Your Honor. I would suggest to the court that absolutely this is the time to raise this issue. Absolutely, if we don't raise this issue, it might be considered waived, might be considered procedurally barred. But more important than that, it's important to the court. Your Honor is going to spend weeks going through motions and evidence and trial. And if we can know on the front end that this offense, this punishment is cruel and unusual, as set out in count 3, why in the world would we want to waste our time hoping for the best, a lick and a promise, we'll see what happens 2-3 years down the road? That doesn't make sense, Your Honor. I think the courts have told us, contrary to the state's position, I think they tell us that in fact we should look at constitutional challenges at the earliest possible time. This is the earliest possible time. Question then is the mandatory life sentence for murder based upon, again, a very specific statute, cruelty to children in the second degree, is that unconstitutional? That's the question for the court. We've got an answer to that question, and it is yes. Who's answered that for us? The General Assembly did. They told us very clearly when they enacted the new legislation. Our governor told us that was the case before this event ever occurred. Signed into law, here's what the law should be in the state of Georgia. It's unfortunate that they didn't put in there an enacting provision that made it effective at the time of signing. They could have, they did not. But the court tells us very clearly that doesn't stop us and in no way prevents this court from looking at the constitutional protection at issue. The Supreme Court's told us yes. They've told us that cruel and unusual punishment, this constitutional protection, should be looked at by the court, even if the law at the time the offense occurred was different. And that's the second part of the state's brief, is suggesting, well, you can't go retroactively applying the law. You know what? They're right. And that's not what we're asking the court to do. No one's asking us to retroactively apply the law. What we're asking the court to do is to powerfully enforce the constitutional protections that Mr. Harris has. That's what the Supreme Court tells us. They told it in the Wilson case, in the Bradshaw case, Adams case, in the Dawson case. Yeah, even if the law at the time was different, even though it's been 2 years since the offense that we're looking at it, that when the court is looking at cruel and unusual punishment analysis, we're not retroactively applying a new law. What we're saying is, whatever the law is, let's look at it in context of what our evolving standard of decency tells us. We had the beauty in this case, we knew it before this offense even occurred. We knew it, and it's clear. Nearly every other state recognizes this in their passing of laws, and the most of which, as I can see, is 48 that go on the side of this being cruel and unusual punishment. 2, given the benefit of the doubt of one that's frankly a little bit hard to understand, only 2 others that I can see even consider a life sentence as being possible punishment for this offense. What is the standard of decency? Standard of decency says, for a very, very unique, specific crime, there's a very unique, specific punishment. That's what everybody's told us. And to suggest that, well, we're stuck with whatever the law was at the time, which is what their brief suggests, simply flies in the face of what our Supreme Court of the United States, the state of Georgia, our governor, the General Assembly, and 48 other states have told us. What's Your Honor's answer to that question? Well, we believe that Your Honor will follow the law. Your Honor will follow the guidance that was given to it by the Supreme Court of the United States, of the state of Georgia. This does not impact in any way the other counts that the state has. It simply eliminates the very unique charge that the state was stuck with, if you will, because the legislature had already acted. When we look at all this in total, Your Honor, there could be no question. This is a cruel and unusual punishment to have the potential life sentence or life without parole sentence for count 3 of this indictment. Because of that, we ask the court to quash this indictment for that constitutional violation. Thank you.
Thank you.
Your Honor, I think I'll start out with what I believe is kind of the gateway issue here regarding the timeliness and whether this is even right. Defense counsel cited, I can't remember the name of it, I believe it was 14A1702, I think it was Jones, 2015 case, regarding that the appellant at that case needed to make this argument at or before sentencing in that case. Also, Pierce versus the state, which was a Court of Appeals case attacking a state statute. First of all, Judge, this case provided Your Honor with all the cases I'm going to be citing here today. The first case I'm citing to is Brinkley versus the state, 291 Georgia 195. It's a 2012 Georgia Supreme Court decision. I believe the defense has a mistaken reading of this case. They talk about it being that we're looking at a sentencing statute here, not a state statute. Brinkley versus the state was a life sentence in that case. That was a mandatory life sentence for kidnapping with bodily injury involving a 14-year-old defendant. The Brinkley court held that the first opportunity a defendant has to bring a constitutional attack against a sentencing statute, which is exactly what we have in this case, which is exactly what they had in Brinkley, as opposed to other types of statutes, may come only after the guilty verdict is returned and the sentencing issue becomes right. In Brinkley, you had a 14-year-old defendant who was involved with and convicted of kidnapping with bodily injury. The mandatory sentence in that case was life in prison. They attacked that as cruel and unusual punishment. In that case, the Supreme Court held that it was not right because the defense did not raise it until the motion for new trial. Now, when the courts say that it has to be raised before sentencing, what these cases all explain, if you read them, is that the issue has to be raised upon the verdict of guilty or at the sentencing hearing before the sentence is exacted. And these cases hold that they cannot be raised until there is a verdict in the case. So I believe if you read the cases and a proper reading of the cases, you would see that. As far as this being a sentencing statute versus a state statute, all of these cases, the kidnapping with bodily injury case, you have the elements of the crime, and then at the bottom of the statute, you have the possible sentence, or the mandatory sentence. Same thing with murder. The elements are at the top of the statute, the bottom is the sentencing provision. That is what we are looking at. Jones versus the state, which is also a 2012 Supreme Court case, furthered this and stated that a constitutional attack on a sentencing statute, unlike a statute under which the criminal defendant is prosecuted, may be made after the guilty verdict is returned, as the first opportunity to challenge such a statute does not occur until after that time. This case specifically involved a defendant who beat an adult victim. In that case, the defendant then abducted the adult victim and children. The children were not even harmed in this case. The defendant was convicted and was sentenced to 25 years to serve without parole for kidnapping of a child under 14 years of age. They alleged that was cruel and unusual punishment as the children were not harmed and things of that nature. Your Honor, in that case as well, they determined that the issue has to be raised after the guilty verdict, but before the sentence is exacted. Woods versus the state, 2005 Supreme Court cases, 279 Georgia 28. Quote, it would be unreasonable to require a defendant to challenge a sentencing statute prior to verdict because a potential acquittal would obviate the need for such action. This was a case involving an argument that a drug statute calling for the same maximum sentence on attempted drug cases as completed ones constituted cruel and unusual punishment. Again, in this case, the defendant challenged at the appropriate time after the verdict was rendered, but before the motion for new trial. So, Judge, I don't know if you want me to continue with my argument. I can as far as the other details, but I think the law is clear that as a threshold here, this case, it is not ripe and it's not proper to even address the constitutional issues.
I'd like to break this point here, whatever response there may be.
Okay, thank you, Your Honor.
Well, it's very easy, Your Honor. Both of those cases they decided to deal with a range of punishment. That's not what we're dealing with in this case. If we were dealing with a range of punishment, it makes sense. Well, how do I know if it's cruel and unusual? If the court only gives you 1 year to serve, it really doesn't matter that the maximum is 30 years. That's why, in those cases, you don't raise it until after the sentencing is involved. It has been done. This case does not have that option. is a mandatory life sentence. There's only one sentence that the court can impose. I don't know how much clearer it can be. I understand that the state says this is the same thing as what was happening in Brinkley. It's absolutely not. Read Brinkley. There's a 1710 which is in the criminal procedure code, not in the criminal offense code. That's the difference between these two cases. That's why this is in fact the proper time to raise it.
Well, I find it proper to be raised once you see what a jury does. And then you've expressed your objection to your motion. You preserved it for that time so that you don't have to worry about a procedural default. And so when we see what a jury does with count 3, then we'll come back and readdress your argument before any sentencing, if in fact the jury finds the defendant to be guilty of that, or if there is evidentiary support for lesser improvements. But let's take a 5-minute break.
Sure.